Hello, everyone. On behalf of the Canadian Association of Refugee Lawyers, Osgood Hall, and the Refugee Law Lab, we'd like to welcome you all to our panel, Accessing Refugee Protection and the Digital Border, the Legal Implications of Passenger Name Record Exchanges. We're very excited to introduce our amazing speakers, and we are looking forward to having some great discussions. So before we get into it, we're just going to start with a land acknowledgement. As we have come together virtually and in person today, we would like to acknowledge the history of the land on which we are gathered. Osgood Hall is built on the traditional territories of many nations, including the Mississaugas of the New Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee, and the Wendat peoples. This land is also subject to the Dishwithlin-Spoon Treaty. The Dishwithlin-Spoon Treaty is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and learn and take action into the future. So to start, I'm honored to introduce to you the chair of this event, Dr. James C. Simeon. James is the Associate Professor in the School of Public Policy and Administration, Faculty of Liberal Arts and Professional Studies, and a former head of the McLaughlin College, Director of SPPA, and a former acting director and deputy director at the Center for Refugee Studies at York University, Toronto, Canada. He served as an IRB member for 11 years and currently researches international refugee law, international human rights law, international humanitarian law, international criminal law, and public policy and public administration.
Thank you very much, Dia, for that introduction. And hello, everyone. Anyone who's traveled by air recently is aware of how automated immigration and customs screening has become the norm of the day. Everything seems to be included, including electronic fingerprinting, checks, iris scans, passport scans, and the ubiquitous headshot, along with the list of kiosk questions that you're required to fill in. Technological tools to screen travelers seem to be pervasive wherever you go these days, but most especially in the global north. Entry and exit controls at border points are the mainstay of all governments as a mark of their sovereignty. And as in all manner of things, it seems, governments are always seeking cost efficiencies in conducting their governmental functions. But when governments legislate the use of travel industry records for their own ends, what are the consequences, and particularly for those seeking asylum? We have two highly distinguished authorities on the subject who will examine the issues concerning all of these aspects. Now, Elspeth Guild and Didier Bigo are no strangers to York University. They're both fellows in the McLaughlin College, which is our public policy college here at York University. And Elspeth Guild is a professor of law. She's the Jean Monnet Professor ad personam at Queen Mary University in London, as well as the Radboud University Nijmegen, the Netherlands. She's also a partner with the London law firm of Kingsley Mapley, and she's also a visiting professor at the College of Europe in Bruges. Her interests include, and her expertise include the area of EU law, and in particular EU justice and home affairs, including immigration, asylum, and border controls, and criminal law and the police, and judicial cooperation in criminal matters. She also researches EU privacy and data protection law and the nexus with human rights. She's also the co-editor of the European Journal of Migration and Law, and she's the co-editor of the book series on immigration and asylum law and policy in Europe, published by Martinus Meinhof. And Didier Bigo is a research professor of international political sociology at the Sciences Po Paris-CERI, France. He's also a part-time professor at King's College London in the Department of War Studies. He's also the director of the Center for Study of Conflicts and Liberty and Security, CECLS, and the editor of the quarterly journal, Cultures and Conflicts. And he's one of the co-editors of the new journal, Paris, which is the political anthropological research on international social sciences. And he's also the previous co-editor with Rob Walker of the ISA journal, the International Political Sociology, excuse me. And most recently, he was the principal investigator for France of the international ORA project Guardian, which was the oversight and intelligence networks who guards the Guardians. And that was from 2019 to 2022. Our first speaker today is Didier, and I'll turn the floor over to Didier.
Thank you very much for your invitation. It's a real pleasure to be here, especially after the years of COVID, that we were here before this year. So it's such a pleasure to be in live and to be on a hybrid mode. I will present first the argument about the PNR concerning national security and what are the relation with what has been called preventive security, and also a lot of discussion about automated artificial intelligence to ask what is at stake. And Elspeth's guide after will engage more on the legal debate. I remember you, I'm a sociologist. My knowledge of law is very weak, but a specialist is Elspeth. But I would like to go back to the origins of the passenger name recalls. Because contrary to what might seem, there is no single form of security, be it national or global, but different forms of security or insecuritization process that are contradictory and can be mutually destructive. This is the case between a preventive, predictive security based on the logic of suspicion and a form of security based on law enforcement and making reference to a penal system based on the principle of innocence. Criminal justice is a well-known and shared principle of democratic regime framed by criminal law under the logic of inquiry and through an evidence-based investigation. The process begins after the crime has been committed. It includes the surveillance and interception of suspects once significant preparatory acts have been discovered, but it's seen as a reactive system, even when it involves intelligence-led policy. The 9/11 Commission report in the USA and the executive under President George W. Bush, in particular its Defense Secretary Donald Rumsfeld, considered that this concept of security and policing was obsolete. In the face of the type of violent action, they say attacks to highlight the war dimension of the future dangers of the use of biological, chemical, and nuclear devices, to which they have been victims. And they put forward an agenda and policy that they believe that you could act preventively to anticipate the terrorist act before it happened. It was emphatically claimed that it was necessary to discover and anticipate the unknown elements of the world through a global and total understanding of its myriad trajectory and to detect the anomalies in the system of systems until finding the abnormal behavior of some actors. That's banal, I say, but it needs to be remembered. Because the idea of this 1% doctrine will justify a total information awareness by following all activities and focusing only on some very specific case of danger instead of monitoring only some individual and looking at their network was to develop a total predictability by applying risk factor calculation to anyone who wanted to travel to the United States, to anyone. And to try to catch the terrorists with predictive tools that would detect them and their accomplices, even if they did not have obvious connection. The use of digital tools capable of detecting weak signal, i.e., the hidden networks of relationships they have within the vast amount of data tracking passengers and their past and present behavior, was seen as a revolutionary method, creating the possibility of monitoring and taming the future. To avoid a worst-case scenario, internet and smartphone surveillance was declared an urgent priority, along with tools to locate and identify the real people traveling from abroad to enter US territory. The passenger name record was born out of this idea that it was necessary to act before the next attack. William Perry puts it in November 2001 article in Foreign Affairs. The US Aviation and Transportation Security Act of 1911-2001 was passed in order to start monitoring passengers and to generalize electronic pre-border check, despite the consent of airlines, foreign governments, and IATA. Airlines that choose to refuse to transfer their commercial data will not have the right to land on US territory. So they had to organize their information on passenger identity and preference into a list of 34 security criteria relating to the identity of passengers, but also to some situational and relational elements, such as the seat number of the plane, to check that the nearly seat is not that of someone already suspected. I insist on that because it's very often forgotten, and that may be one of the key elements for the intelligence services. It's not so much the authentication, that this kind of relational possibility to connect people that are not connected, that it has taken. So the PNR is therefore initially transformed from a commercial activity to a security tool as a result of this reversal perspective in favor of prioritizing predictive, anticipatory security in the name of a belief in prevention that is sufficiently effective to prevent future attacks. Of course, its American origin in the war on terror and the idea of total information awareness should not be forgotten, but they are not all the story. If you look more in detail, and I will not go too much on that, the idea already to have connection for locating individuals and to connect the idea of following people when they travel existed from the Schengen Information Platform before 9/11 and not under the idea to prevent terrorism, but to fight against illegal migration. But the Schengen Information System, which was one of the first really general platform where you had security and border control together, changed the logic and put this data together, while, and that's very important, being very sure about the kind of access that each group could have. And so the police was restricted to police, the border guard to border guard. After the 1990s and the Schengen Information System 2, which was in fact a search engine, it changed a lot because it came immediately after the bombing of Madrid 2004 to create a kind of function tree in terms of the possibility for police to get information which were before only to the border guard, and for the intelligence services to take information from the border guard and from the police. And that's something which is really important because it shows that what is really important in this element are the facts that now we have a change in the way this organization of the system is working. The current ruling on the legality of the EU PNR Directive of 1 June 2022 can be considered a landmark decision, not only for EU PNR, but for all forms of transnational cooperation involving PNR. Many countries around the world are therefore watching with interest the outcome of the decision for the next design and the use of this technology. I can come back to this design if you are more interested during the conversation. The court insisted on many points. I will insist here only on a few that relate to the preventive dimension and the different interpretation of what preventive can mean. The willingness to predict is based on the belief that the detection of anomalies or weak signals emanating from a small statistical group sharing the same characteristics is only valid if the number of data initially collected is large scale, mass, collecting in mass data. The large, if not systematic collection and storage over a long period of time is considered by the intelligence services and the people who design the system as crucial for the functioning of any predictive analytic algorithm. This implies automatic processing of large amounts of data without human intervention. Human intervention is limited to monitoring the process and intervening after sorting in a very limited number of cases. But the court, on the other hand, insists that the people in the passenger information units check the validity of the data and select only those in which a direct or indirect element can link a specific person to a case. They are reintroducing a logic in which correlations are not enough to establish suspicion. They need to have a causality. This causality has to explain what is a reasonable suspicion. This cannot be a ranking in which many people may have high score for bad reasons. These people are always not called victim, but false positive. We can come back to that also. Unsurprisingly, some governments are very uncomfortable with this element to limitation that the court has given, because the court is coming back to this idea that security cannot be preventive, cannot be predictive. Security has to get guarantee and has to respect the criminal justice logic. The judgment insists on the fact that a control by an external actor verifies that the collection of data is strictly necessary. I asked my colleague in law, do you have a difference between necessity and strictly necessity? And they say, no, not really. So I can infer from that that the judge wants really all the people to think about the strictly necessary means that you cannot choose yourself what is necessity. You have to follow the criteria we give. And of course, that's really what government, especially counterterrorism law enforcement, which were the first on this topic, and the private companies which are helping them to build this technology of PNR have considered impossible to meet with what they have already done. They have already done many things because they always use the same technique or the same form of governmentality, because they always create for the next 20 years tools which are tested technically, but very often without clear legal base. And after they always say, we spend so much money that you cannot go back. So one of the elements, which is, I think it's the core of this debate, is that we have accepted permanently the idea that security can be prevented, that it can predict, and that you can monitor the future and the future behavior of individuals. Now the court has put some condition under it, but nevertheless, they are not to challenge immediately the core of the argument. And they continue to differ that it's to the government to delimit what is security. If they want national security to still be preventive security, they can. They can in theory, but they cannot now anymore in practice. So we are at this moment of tension. I think it's really important, and it is therefore really the time to analyze what that means. I finish with a very last point. We had made a lot of interviews with these people, Laurent Bonelli, Francesco Ragazzi, myself, and here Karine Côté-Boucher, and so on. And they show that at the core of the operator of counterterrorism, they consider that it's more important for them to have traditional method, that they have a reasoning, which is a reasoning in terms of conjectures, like Ginsburg said, and not an algorithmic reasoning. They use the tools of internet for that, but they don't want either of this algorithmic reasoning. Why? Because it creates so much false positive that they spend more time to eradicate the false positive than to work on the topic. And so beyond the argument, of course, of privacy, human rights, and so on, even for the service, this change that the court has done is really important. Thank you very much.
Hello, everyone, in the room and online. And I'm going to bring this discussion down a level to practices, and particularly practices around refugees. What does all this mean for refugees? And I fully subscribe to the way Didier has positioned the debate. And I'm going to dig into some of the detail around what this means and where it's taking us, but very much from a European perspective. So I'll be very interested to hear what everyone has to say from here. So If we then bring what's happening down to the refugee, we have, of course, our definition of a refugee. We have the migration of the non-refoulement right to other instruments. And whenever anyone starts talking to me about what should we do with our environmental refugees, I say, wait for the next convention and see if non-refoulement creeps in there, because that's what we're doing with it. And we have the obligation not to put penalties on people who are crossing borders. So if you are a refugee and you cross border regularly, that's it. They have to treat you, they have to give you a proper asylum determination process. What has happened in respect of the claim of the importance of border controls to state sovereignty, with the duty of states to allow refugees to cross borders and to receive a protection and a fair and efficient asylum procedure? So we can see this since about the 1980s, and Thomas Gammelstock Hansen was one of the first to start talking about this with a couple of the colleagues in Aarhus at that time, because the Danes were among the first to introduce the safe third country presumption into international refugee law, much to everyone's great concern. And Elspeth Hansen at that time was writing about this, and we all said, oh God, is there a Danish originality in all this? But anyway, this of course has now disturbed massively Canada, and I've just been hearing and learning all about the Roxham Road and the consequences of introducing a safe third country presumptions. But that was one of the first tools. One of the other tools was that to prevent arrival of those who might seek asylum, the idea that unless the refugee can get to the border, you don't have to deal with them. So this is the whole problem in the Eastern Mediterranean about pushbacks, the trouble that the Greek border agency has got itself into, the European border agency, Frontex, in unlawfully pushing back people to prevent them being able to seek asylum, and the reinforcement of traditional tools to prevent asylum seekers, refugees from arriving, the mandatory visa requirements on most refugee producing countries, and carrier sanctions to make sure that that the airlines don't carry them. So all of that is pretty ordinary. And then our friends in the technological world came forward and offered some new tools. Looking at the lay of the land, looking at where the contracts are and the interest is, our colleagues in the technical world said, well, if you want to keep refugees out, we can provide you with tools that will assist you to do that. You don't have to rely on the stuff that clearly hasn't worked. There will always be a Roxham Road somewhere. As soon as you have a third country presumption, asylum seekers are always arriving irregularly without visas, etc. So those who were concerned about implementing the state's sovereignty perspective of border controls, we only let in those we want to let in, got very excited in the new tools. So the first thing is that we have the problem about it is, what is AI? And from a legal perspective, looking at a number of uses of AI by government in the UK, I've come to the conclusion that AI is any use of technology which is seen as a success, and AI is never use of technology which is a failure and leads to a scandal. And in the UK, we've had a series of scandals of the use of AI in voice recognition for students in their language tests, English language tests, resulting in thousands of students losing their visas and being deported or told to leave. We've had huge AI scandals about university clearance, who gets into which university, and using AI tools here. And every time our techie colleagues say, well, no, it's not really AI, but it of course is. So the definition which I like best is this one, which is basically like cake recipes. You put in a bit of this, you put in a bit of that, you put in a bit of that, you put it in the oven, it rises, and you have a cake. So you're given a bunch of objectives, by the people who want the AI, the algorithm, the techies, then put the doses in the right amounts to achieve the result, the cake you want. They put it in the oven, out it comes, and there we are. The legal challenge is, of course, who's setting the objectives, and this is something which is often obfuscated about what were the developers told to do. Someone gave them a set of criteria, we want this, and then they go about trying to deal with it, determining what the criteria are, and I'll come back to that in a minute. Deciding what evaluation is any of this worth anything? And this comes up again and again in the court judgments where the states are required to reveal information about how much data they have been siphoning out of the system for what kinds of results. And how do we define success? What is success? And then that's something which someone raised with me a couple of days ago. Once the program, an AI program, has been designed and it's put into practice, how is it revised in order to ensure that it doesn't become obsolete? As in all of these technical programs that we use are endlessly needing to be updated as they adjust to the changes in both technology and information which is available. So why AI? What is it that has been sold to our asylum determination officers and our border control departments? It's a mechanical solution, and it's about having massive amounts of data through which you can ask a question to identify targets which you have predetermined. So stuff where you couldn't possibly put people to work sifting through massive amounts of data about passenger name records, but you can use an AI tool, but you need to tell the tool what you want to find. And the prerequisite, of course, is too much data. Machine learning, and I'm going to identify this out a little bit because it's become a big problem from the legal perspective, is including into the AI algorithm the capacity for it to improve itself, to achieve a better result continuously by adjusting bits of its own algorithm. So as it sees trends developing and it checks that against what the objective was that it has, it can kind of modify the process. The Court of Justice of the European Union, in this case that Didier has been talking about, defined ML as the use of artificial intelligence technology in self-learning systems, machine learning, capable of modifying without human intervention to review the assessment process. And this is the first time I've ever seen a court define what ML is. Why has the court defined ML? Because it's going to stamp on it. And I'll come to this at the end. Because what it needs to have a clear definition of what this is to find that this is illegal in decision making. Now we'll come to that at the end. So what is PNR? Well, Didier has given you a bit of the background. It's all the data we put in to buy an airline ticket. So between us and the airline, we'll need addresses, phone numbers, meal preferences, and all of this stuff, which one of the big difficulties of PNR is this is all unverified data. You can put in anything. As you know, you can buy an airline ticket perfectly happily with 5 spelling errors in your name, the wrong address because you put down your boyfriend's address instead of yours that your credit card was attached to, and it had no consequence for being paid. The only thing that has to be right is the credit card number, the expiry date, and the CCV code. Everything else can be wrong. So what's going into the system is massive amounts of inaccurate, unverified data. Secondly, one of the things about PNR data which makes it really different from a lot of the other data which is being used in databases around border control, which is normally that data is about non-citizens, about foreigners. and the whole US approach that you can do anything with foreigners' data because they don't have constitutional rights to protection of their data. PNR data is everyone's data. So here you capture your citizens who are coming home, as well as aliens who are coming in. And that's one of the issues which, in the whole debate about PNR, there is a tremendous temptation to try and whitewash that out of the system. That the people whose data is being interfered with include people who have constitutional rights in the countries they're going to. So it's not merely international and transnational rights. Why do states want this data? Well, the ostensible reason, which goes into the agreements, is to fight serious crime and terrorism. And in the EU context, its use for border control is not permissible. Okay, so the only justification for the interference with personal data, the collection by border authorities of the PNR data, is not for border control purposes. That is considered to be an insufficiently important justification for the enormity of the interference with the privacy right. And the only objective which is consistent with this enormous interference with privacy rights is serious crime and terrorism. We'll come back to that in due course. What is then done with PNR data? Well, there are two things. First, it's checked against other databases. So criminal justice databases, this is one of the reasons why in Europe there is extraordinarily strong limitations on access to any databases about who has a criminal conviction. Unlike the United States, where anybody can find out anything, it's considered to be an element of privacy of intense prejudicial import. But there are also databases about terrorism. We set up a terrorism database not too long ago. But it's also possible to check PNR data against asylum. And one of the things Didier didn't talk about was a project ongoing in Europe called interoperability, to bring different databases together, so fingerprint databases and all that kind of stuff. The second use of PNR data is to run through what are called predetermined criteria. This is criteria. So among the classic criteria which to run through PNR data is, for instance, the A2 is told, keep an eye out for nationalities. Somebody is flying from London to New York. They are an Afghan national. They have a valid visa, but we want to do a secondary check. We may want to do a secondary check because Afghans are really scary people. So that would be this kind of predetermined criteria. It might be an Afghan males between 18 and 35. We'd say, well, these are predetermined criteria of terrorism threats. So you have the question of a generalized predetermined criteria, which are applied in a systematic manner, generalized manner, and they have no objective ground on the basis of the specific individual. And these result in hits. So we have on the one hand, the databases and the predetermined criteria. And we'll see how in the European context, both of these run into difficulties. What are the consequences? Airlines are told not to allow people to board, preventing boarding. This for the refugees, this is disruption of the flight. You get stuck somewhere where you don't want to be. A lot of refugees, particularly Iranian, seeking to get to Canada, often run into difficulties where they're stopped on the basis of various different things in European centres. London has been one, but also Amsterdam. The possibility that you're going to be excluded from the definition because you're never going to get outside your country of origin. Your details may be added to a no-fly list. And your data, now that it's gone through the treatment, your PNR data has gone through the checking against databases and against the predetermined criteria. And then your data may then be shared through data sharing agreements, such as that between the UK and the US border data sharing agreement. So this is automatic sharing of data on immigration and asylum. How do states get PNR data? Well, they require the airlines to give it to them. And what's the problem? Well, the problem is privacy. So for instance, let us take Lufthansa. Lufthansa is required to provide all PNR data on flights going to the US to the United States government before boarding starts. In fact, I think it's now 48 or 72 hours before departure. But European data protection rules say the US can only get data if they have a ground to seek it. Our general data protection regulation applies. So to get around that problem, an agreement has to be reached between the EU and the United States, allowing the US government to require PNR data. And I'm going to pass over the Convention 108 on the problem of this data. You can look at that generally. So the PNR data is collected in one state by airlines, it's the private sector, and transferred to another state. And in the EU context, that can only be done if there is an agreement whereby the country that's getting the data has in place sufficient privacy protections to justify this interference with the individual's right to privacy. So in 2017, we had the Court of Justice knocking out of place the EU Canada Passenger Name Record Agreement, saying that this is all no good. It's not consistent with EU privacy rules. That's Article 7 is the right to privacy, Article 8 is the right to data protection, and Article 21 is the prohibition on discrimination. And why did the court strike out the EU Canada agreement? It was because the agreement does not preclude the transfer of sensitive data from the EU to Canada and the use and retention of that data. So the sensitive data was the final point. So everybody has sat back. They've been trying to renegotiate that treaty ever since. We still haven't got an agreement. But probably illegally, data is still being transferred. What is the basis internationally, if we step beyond our own EU stuff? Well, it's the International Covenant on Civil and Political Rights, Article 17, the right to privacy. And the right to privacy is seen as a gateway right through which other interferences with rights may take place, but it's the principle, a legal principle by all the states which have signed and ratified the ICCPR, is that no one shall be subject to arbitrary or unlawful interference with privacy. And that is linked then also to the principle of non-discrimination. So then we get to the 2022 judgment that Didier was talking about. So the case was about two types of PNR use. One is with third countries and the other was intra-EU. For our purposes, we're really interested in the EU third country, because this is where EU privacy standards begin to establish an international norm where other countries will need to comply with the privacy rights, which the EU says are based on Article 17 ICCPR as incorporated into EU law under the data protection regulation, and therefore becomes the new international standard. Now, you know which country, the big one to the south of here, which is really opposed to this, what they see as legal imperialism by the EU in respect of the right to privacy. So the first thing that came up was purpose limitation. This data, PNR data, they say, okay, you can have data sharing agreements on PNR, but they have to be limited to serious crime. Serious crime has to be defined within the agreement, and according to the court, this is a crimes which carry a maximum sentence of 3 years imprisonment. Under serious, who knows? At least it's not on the basis of what the content of the crime is, because as you know very well, in Canada, the question of recreational use of cannabis is has resulted in just huge interjurisdictional problems about what is a crime and what should be treated as crime, what are the outcomes of crimes. And the other is terrorism. But here, the court said, oh, this isn't just anything you want to call terrorism. This is terrorism insofar as it affects national security. So all of a sudden, all of the uses of PNR data, supposedly based on the risk of terrorism, become limited by the court, in that not only does it have to be a claim that there's a terrorist threat, but that terrorist threat also must then be tied to national security. And in another judgment, and I'm not going to go into it, the court said even national security can have a common European definition. Then it said, okay, what rules of data protection apply? The private companies, the airlines, have to apply with the normal private sector rules. They don't get to use in the collection and the sharing of data, the legality of the collection and sharing of personal data. They cannot be somehow given the state's more extensive entitlement to interfere with privacy, which is contained in a special EU directive, which applies only to law enforcement authorities. So it can't be kind of lent to the private companies so they can do this work for the state. No, they must comply with the normal civilian rules in respect of privacy. They cannot use those which are the more extensive interferences with privacy, which are inherent in the law enforcement context. Law enforcement can only use the more flexible rules if it is for criminal justice purposes. And here, the court looks at what everybody calls law enforcement, and they notice that the council has inserted intelligence services as part of law enforcement, and a whole bunch of agencies which are encrusted on the side of all kinds of things, and included them in law enforcement. And the court is basically saying to everybody, we know you've been doing this, and no, you cannot use these more extensive rules on the interference with the right to privacy unless it is specifically within the criminal justice field. So that was really a big tap on the nose to the intelligence services, because they're not going to be able to get it. And the untargeted personal data use is accepted. So they say, okay, you can do the criteria. So now they've dealt with what are the rules, they've kicked out the intelligence services, and then they go on to determine what about the predetermined criteria. Noticing like citizenship and age and gender and possibly economic status or educational criteria. These are all real favorites that our policymakers give to the coders as predetermined criteria that we want. And in the UK case, what they did was they put into a traffic light system where there were green cases that the official makes that decision to just let go, yellow that the official should have a look at, and red where we're going to need to look much more depth. So the predetermined criteria are going to have to be applied in a systematic and generalized manner. Okay, so I have to apply to everything. That doesn't bother anybody. Regardless of whether there is any objective ground for considering that the person is a risk. And this is exactly Didier's argument about the slide into suspicion, generalized suspicion, and away from the presumption of innocence. What does the court do to try and rein this generalized suspicion back in? They use non-discrimination. And it says that the non-discriminatory nature of the databases, that means that the databases in the first case, where we're checking the PNR data against databases, those databases must be non-discriminatory. Well, even the PNR data is discriminatory. And the entry on the databases of persons who are sought on the basis of an alert should be objective and non-discriminatory. And in respect of the predetermined criteria, the databases are going to must be used in relation to the fight against terrorism offences and serious crime with an effective link to travel. Now, our predetermined criteria are also going to have to be non-discriminatory in manner and in no circumstances be based on race, ethnic origin, political opinions, religion, philosophical beliefs, trade union membership, health, sexual life, or orientation. Okay, so we now have a list of the prohibited discrimination. And the court goes on to say the discrimination non-discrimination covers both direct and indirect discrimination. And as you can see, even something like nationality can be a proxy discriminatory ground for race or ethnic origin. Age may be a problem in respect of health. It might be a proxy depending on how it's being used. Almost everything, all these criteria that are and those who are the instructions which are being given to the coders are being given to what should be the predetermined criteria are questionable on the basis of the non-discrimination requirement. And then the way in which member states use it must be non-discriminatory. So what then happens to our refugees in the digital border? Well, the first question is who is in what database and for what purpose? So if PNR data is being shifted around, does someone crop up and how do they crop up? What about the purpose limitation as regards AI use in databases, in particular as regards databases which contain only asylum seekers data? Data sharing agreements, what data is being passed along countries which may make it impossible for a refugee to travel to one country, but then also to another country or a third country, depending on how their data has been used. The question of the predetermined criteria and discrimination is, having been a rejected asylum seeker, a ground to be for the criteria for the artificial intelligence algorithm to be discussed, and our problem of direct and indirect discrimination and the proxy element of that criteria. That's the end of my PowerPoint. And I would just say, after the judgment came out, the council, which represents the executives of the member states, their legal service, sat down and went through the judgment, which is very long, it's about 70 pages. And they drew up a list of questions for the member states about how they would like to address reorganizing the system to comply with the PNR judgment. And it makes extremely interesting reading. It's you can see the lawyers have gone through this step. None of this works. All of this is incompatible, and we don't see how we're going to get around it. But most importantly, the court said no machine learning, because machine learning destroys the whole basis of law, in that the outcome means you have no idea what the reasoning was, which resulted in the decision. So that's where we are at the moment in the European Union. I'll close the file there, and I will hand back to somebody for questions. Whatever it is he's going to.
And just before we get to a question, the practice at the Refugee Law Lab is not to record Q&A, so I'm going to end the recording here.